In August 2008 as an associate professor and administered the chair in consumer law and practice established by Ministry of Consumer Affairs. Since taking charge of NUSRL Ranchi as the Vice Chancellor in June 2023, his leadership, vision and commitment to education has profoundly impacted the growth and success of our institution. It is my honor to now invite our respected Vice Chancellor, Professor Dr. Ashok R. Patil, to deliver the welcome address on this occasion. Sir, we really look forward to your words of wisdom and encouragement.
Good evening, everybody. Respected Honorable Chief Justice, High Court of Jharkhand, Chancellor, NUSRL Ranchi, Justice Tarlok Singh Chauhan, Honorable Mr. Justice Sujit Narayan Prasad, Judge, High Court of Jharkhand, Sri Raju Ranjan, Advocate General, State of Jharkhand, Dr. Amandeep Kaur, wife of Chief Justice Tarlok Singh Chauhan, and visiting faculty of our university, Sri Neeraj Kumar Srivasav, Principal Law Secretary, Government of Jharkhand, Sri Radha Krishna Gupta, Advocate, Sri Rajendra Krishna, Chairman, Jharkhand State Bar Council, all AC, EC, GC members, and High Court Registry, Sri Satya Prakash Sinha, Nikesh Kumar Sinha, Vishwanath Shukla, Ashok Kumar, all deputy registrars and other officers, Jalsa director, and the director, officers of Judicial Academy, advocates, electronic and print media, dignitaries, participants, esteemed faculty, and dear students. Today, we gathered here in the inaugural session of 2 days national seminar on 25 years of the Indian Constitution, contemporary reflection and future directions. It's a movement of profound pride and responsibility to address this August gathering on the eve of Constitutional Day, a day that reminds us of the soul of our republic and the ethical blueprint upon which our democratic existence rests. Constitutional Day is not merely commemoration of a historical milestone. It is a reaffirmation of our shared commitment to justice, liberty, equality, and the rule of law. For an institution like NUSRL, Constitutional Day holds special significance. A law university cannot remain passive observer of constitutional ideals. It must serve as their active custodian. Our obligation is not limited to academic instructions alone. It extends to translation constitutional principles into lived realities, especially for those whose voice often go unheard. One of the most meaningful ways in which NUSRL has upheld constitutional principles is through its sustained commitment to legal aid and access to justice. Our legal aid clinic, driven by dedicated students and faculty members, has consistently worked to bridge the gap between law and society. From providing free legal assistance to marginalized communities, to conducting legal awareness camps in rural and semi-urban areas, these initiatives embody the Constitution's directive to ensure equal protection of laws. A significant area of our engagement has been the study and advocacy for rights of under trial prisoners, a segment often forgotten within the criminal justice system. Through rigorous field research, documentation, and legal interventions, our students and research teams have highlighted systematic issue such as prolonged detention, lack of legal representation, and procedural delays. In doing so, they have not only contributed to academic discourse but also reaffirmed the constitutional mandate of personal liberty and fair trial. NUSRL commitment to constitutional service has further been strengthened through collaborative projects that align legal education with social empowerment. Our legal aid program and the training of young law professionals developed in collaboration with Ajim Premji Foundation represent a significant step towards nurturing socially responsible legal practitioners. These initiatives focus on sensitizing young professionals to grassroots realities and equipping them with the skills necessary to serve communities with empathy and competence. Another noteworthy initiative is the project Nyaya Setu, which reflects our belief that law must travel beyond institution and reach the lived spaces of ordinary citizens. Nyaya Setu is designed to spread legal awareness among workers, particularly those in unorganized sectors, while simultaneously facilitating their skills development, capacity building. By empowering workers with legal knowledge and life skills, this project seeks to transform awareness into agency, a core aspiration of our constitutional framework. These initiatives demonstrate that NUSRL does not view the Constitution as a theoretical construct but as a dynamic instrument of social change. Through its various centers, research wings, and student-driven programs, the university continues to embody the spirit of participatory democracy and inclusive justice. Our students stand at the heart of this mission. They are not merely recipients of legal education but active participants in the constitutional process. Whether through prison visits, legal aid drives, empirical research, or policy advocacy, they experience the first-hand, the human realities behind legal doctrines. This engagement instills in them a deeper understanding that law is ultimately about people, their struggle, their rights, and their dignity. As a Vice Chancellor, I have had the privilege of witnessing the transformative impact of these efforts. I have seen students return from field work with renewed sensitivity, sharper insight, and heightened sense of responsibility. This, in my view, is the true success of Constitutional Law University. When legal knowledge is guided by compassion and anchored in service. To our students, I would say this: your education here is not merely pathway to a profession, but an invitation to serve the Constitution in its true sense. Let your learning be guided by integrity, your advocacy by compassion, and your career by pursuit of justice. On this solemn occasion, let us reaffirm our collective resolve to uphold the ideas enshrined in our Constitution and ensure that its promises reach every corner of society. Let NUSRL continue to stand as a beacon of constitutional commitment, academic excellence, and social responsibility. With these reflections, I extend my sincere gratitude to all for your unwavering dedication to the values we celebrate today. May the spirit of the Constitution continue to inspire our actions, strengthen our institution, and guide our nation forward. Jai Hind, Jai Bharat. Thank you.
Thank you so much, sir, for your inspiring word. Now, to add a touch of melody and cultural richness to this inaugural ceremony, I would like to invite Pratibha Priya, first year student of NUSRL, to present a beautiful classical song. Please welcome her with a big round of applause.
Ni sa ga ma pa ni sa ni dha pa ma pa dha ga ma ga re sa ni sa ga re sa तुम मेरे वरदान बनोगे तुम मेरे वरदान बनोगे मेरे सीने की धड़कन में मेरे सीने की धड़कन में तुम अपना ही गान सुनोगे तुम मेरे वरदान बनोगे शहनाई की मीठी धुन पर सपनों की बारात सजाए शहनाई की मीठी धुन पर सपनों की बारात सजाए चंदा की डोली में आना चंदा की डोली में आना मैं बैठी हूँ आस लगाए मेरे प्राणों की वीणा में मेरे प्राणों की वीणा में तुम नूतन झंकार भरोगे तुम मेरे वरदान बनोगे शर्मा कर तुमसे बोलेगी मेघ भरी नैनों की भाषा शर्मा कर तुमसे बोलेगी मेघ भरी नैनों की भाषा अलसाई मनोहार करेगी अलसाई मनोहार करेगी मेरे मन की मौनी पिपासा मेरे कानों में धीरे से मेरे कानों में धीरे से तुम अपना ही गान सुनोगे तुम मेरे वरदान बनोगे मेरे सीने की धड़कन में मेरे सीने की धड़कन में तुम अपना ही गान सुनोगे तुम मेरे तुम मेरे तुम मेरे
That was such a melodious performance, Pratibha. It is now the time to reflect on the growth and accomplishments of our university. With great respect, I invite our Honorable Dean of Academics, Professor Dr. K. Samla, to come forward and highlight the recent achievements and milestones of NUSRL.
Respected Honorable Chief Justice of Jharkhand, Honorable Mr. Justice Tarlok Singh Chauhan, Honorable Mr. Justice Sujit Narayan Prasad, Judge High Court of Jharkhand, Learned Advocate General Shri Rajiv Ranjan Ji, esteemed members of the judiciary, respected faculty, distinguished guests, and dear students. A very warm and respectful good evening to all. I am Professor Dr. Shamla Kandade, Dean of Faculty and teacher of Constitutional Law. It is both an honor and a privilege to stand before this august gathering today. On behalf of the NUSRL Ranchi, I extend a heartfelt welcome to each one of you. Your gracious presence adds not only dignity to this occasion, but also inspiration to every member of our academic community. Over the past years, NUSRL has continued its journey of academic excellence, institutional growth, and meaningful contribution to legal education, research, and public service. Guided by constitutional values, innovation, and academic rigor, the university has strengthened its programs, broadened its research initiatives, and enhanced its student participation and recognition on national and global platforms. Our students have excelled in prestigious moot court competitions, research conferences, internships, public policy engagements, and international forums, reflecting not only legal scholarship, but leadership, social responsibility, and character. As we share these milestones today, we do so with humility and deep gratitude, particularly to the judiciary, the bar, our governing bodies, and our institutional partners, whose support, encouragement, and guidance have shaped our progress. Today is therefore not just a review of achievements, it is a reaffirmation of our resolve to grow as a premier legal institution, deepen our engagement with the justice delivery system, and nurture legal minds grounded with equity, integrity, service, and constitutional morality. With this spirit, I now present a brief institutional report of the academic year. To begin with, I am delighted to share that our Vice Chancellor, Professor Dr. Ashok R. Patil, has recently been conferred with the Indian Achievers Award for his exemplary contribution to legal education and institutional leadership. This honor is not only a personal milestone for our Vice Chancellor, but also a moment of pride for the entire NUSRL community, as it recognizes the collective journey of academic progress and excellence that the university continues to pursue. The Indian Achievers Award is a prestigious award that recognizes individuals and organizations for their exceptional achievements and contributions to India's socio-economic welfare across various fields like healthcare, education, entrepreneurship, and social activism. These awards are presented by organizations like the Indian Achievers Forum and Power Corridors to acknowledge trailblazers who have demonstrated excellence and impact. The Center for Legal Aid Program, CLAP, at the NUSRL Ranchi has been awarded second place in the internationally acclaimed McJanet Prize for Global Citizenship 2025. This esteemed recognition is conferred by the Talloris network of engaged universities in partnership with the McJanet Foundation and is accompanied by the grant of $7,500 in acknowledgement of contribution to community engagement and the advancement of access to justice. The recognition from the Talloris network, which comprises over 400 universities in 92 countries, highlights NUSRL's growing global footprint in engaged legal education. The prize will assist the center in expanding its outreach efforts, strengthening projects such as Project Sarthi, Prison-Based Legal Aid and Rehabilitation Project, and initiating further collaboration in rural and tribal areas of Jharkhand. The club team also received the Best Faculty Coordinator Award in the second Professor V.S. Mallar Memorial Legal Aid Competition in 2023. The university's moot court teams have demonstrated exemplary performance at highly competitive national and international platforms during the academic year. At the FDA International Arbitration Moot 2024 South Asia rounds, the team comprising Ms. Lisa Gupta, Mr. Abhinav Shukla, Mr. Sarthak Kumar, Mr. Suryansh Singh and Ms. Ila Singh from the 2027 batch reached the semi-finals, qualifying further to represent the institution in the global rounds. Additionally, Mr. Sarthak received an award as speaker in the South Asian rounds. At the 22nd William Series East International Commercial Arbitration Moot 2025, the team comprising of Ms. Janaibul Kubra, batch 2027, Mr. Intizar Alam, batch 2026, and Mr. Ataur Rahman, batch 2028, earned significant recognition, including the Neil Kaplan Award for Best Oral Advocate, as well as the Fali Nariman Award for Best Respondent Memorandum, marking an outstanding achievement on the international stage. Further, at the MMCS International Maritime Arbitration Moot Court Competition 2025, the team comprising Miss Ankisha Vandana, Miss Arunima Bali, and Miss Simran Chaudhary from the 2027 batch secured the distinction of runner-up for the Respondent Memorial, reflecting strong research and drafting excellence. These achievements collectively highlight the university's advancing advocacy culture, rigorous training ecosystem, and the outstanding abilities demonstrated by our students on globally recognized platforms. Alongside our international successes, our students have also excelled across numerous prestigious national moot court competitions. At the 3rd P.N. Mathur National Moot Court Competition 2024, the team of Ms. Shreyas Radha and Ms. Ananya K. Sangra from the 2026 batch secured the winner's trophy, demonstrating the exceptional advocacy and research skills. In the 5th Gurjit Singh Memorial National Moot Court Competition 2024, the team comprising Mr. Intizar Aslam, batch 2026, Ms. Jainabul Kabra, batch 2027, and Ms. Muskan Suhan, batch 2027, earned significant distinctions, including the Best Respondent Memorial Best Female Oralist awarded to Ms. Jaina, and also advanced to the quarterfinals. At the 5th NUSRL National Competition Law and Digital Forensic Moot Court Competition 2025, our team of Mr. Yash Sanjay Mani, Ms. Naina Kumari and Ms. Smriti Devendra Jha, batch 24-29, won the award for Best Respondent Memorial, reflecting strong drafting and analytical excellence. The team comprising of Ms. Srijita Lahiri, Ms. Sakshi Sharma, and Ms. Adrika Goyal from 2028 batch secured the runner-up trophy and the award for Best Memorial at the 8th Surana and Surana Raffles University Labor Law Moot Court Competition. Furthermore, at the CCA NUJS National Competition Law and Digital Forensic Moot Court Competition 2025, the team comprising of Mr. Mohammad Shaji Abbas Naqvi, Mr. Aman Pandey, and Ms. Shreya Malviya, batch 2029, qualified through the memo rounds, reached the quarterfinals, and Mr. Aman Pandey was awarded Best Speaker. At the M.M. Banerjee Memorial National Moot Court Competition 2025, the team of Ms. Aditi Verma, Ms. Suhani Sugandha, and Ms. Ila Singh emerged as the winners, while Mr. Abhinav from the same competition earned separate recognition as the Best Speaker. I am very happy to announce here that yesterday NUSRL team won the M.M. Banerjee Memorial Moot Court Competition conducted by the Chotanagpur Law College, Ranchi. Ms. Aditi Verma, Ms. Suhani Sugandha, and Ms. Ila Singh are the team who won the competition. Best Speaker Award was earned by Mr. Abhinav. We are proud to have such excellence in our university and hope that in coming future we will have more bright students as part of NUSRL family. In alignment with the national sustainable goals and our commitment to environmental stewardship, the university successfully inaugurated 3 rooftop SPV battery inverter solar power plants of 100 kilowatts each, total 300 kilowatts, installed at the academic block, boys hostel and girls hostel. The project has been executed through the Jharkhand Renewable Energy Development Agency, JARDA, under a 5-year maintenance agreement. The system is now fully functional and currently supplements our energy requirements as a reliable backup source. Strengthening the campus safety and institutional collaboration with the state. The university has allotted 30 decimals of land to the Jharkhand Police Department for the establishment of a dedicated police outpost. This facility was inaugurated by the Honorable Chief Minister, Shri Hemant Sorenji, marking a significant step towards enhancing safety, administrative coordination and community welfare. Our students continue to excel globally. Sir Mr. Ashutosh Utsav, LLM Commercial and Corporate Law Batch 2023-24, a scholarship recipient, has been awarded a fully funded PhD fellowship at the University of Turin, Italy. Mr. Aryan Raj, a 2025 law graduate, after securing a placement with an investment firm, he is currently pursuing his master's at the International University College of Turin. My lords, sirs, madams, several of our graduates are also serving across various state judiciaries, contributing meaningfully to the justice delivery system. The Kautilya Society at NUSRL has prepared a comprehensive report on the monsoon session of the Jharkhand Legislative Assembly. The initiative aims to make legislative proceedings more accessible to students, researchers and the public. The report is scheduled for release by the government shortly. The faculty members at NUSRL continue to contribute significantly to legal scholarship, publishing extensively across reputed national and international platforms. Their academic engagement strengthens the research culture at the university and enhances its intellectual footprint. The university placement cell continues to secure commendable recruitment outcomes year after year. Graduates are consistently placed across diverse sectors, including corporate firms, judiciary, research institutions, litigation, and policy organizations, reflecting the professional caliber of our students and the confidence of the industry in NUSRL. Aligned with our mandate to strengthen legal education in the state, NUSRL has implemented from the day one of its inception an admission structure reserving 50% of seats for the students from Jharkhand. Further, responding to evolving industry needs, the university has introduced a new BBA LLB 5-year integrated program this academic year. With strong academic momentum, increased research activity and growing student outcomes, NUSRL now stands at a crucial institutional phase. To sustain quality expansion and to meet national benchmarks, the university requires financial assistance from the government of Jharkhand, support through corporate social responsibility CSR framework, institutional funding partnership. These resources are essential for infrastructural upgrades, academic support, research development, and compliance with regulatory benchmarks, including NAC accreditation and an improved NRAF plan. In conclusion, the recognition of our Honorable Vice Chancellor Professor Ashok R. Patil with the prestigious Indian Achievers Award stands as a defining moment in the journey of the NUSRL Ranchi. This award, known for honoring individuals and institutions who contribute meaningfully to India's socio-economic progress, and obviously it actually achieved as a recognition at the national and international platforms. Professor Patil's visionary leadership, commitment to academic excellence, and emphasis on student growth have ushered in a phase of transformation, national relevance, and institutional confidence. Under his guidance, the university has strengthened its academic framework, institutional collaborations, research culture, and student ecosystem, making excellence not just an aspiration but an emerging standard. As we reflect upon the achievements, developments, and aspirations shared today, it becomes clear that NUSRL is not merely progressing, it is evolving with purpose, responsibility, and constitutional ethos. Our students are excelling on international platforms. Our researchers are contributing meaningfully to legal scholarship. Our institutional initiatives are strengthening access to justice, and our outreach is impacting communities across Jharkhand and beyond. With humility and pride, we reaffirm our commitment to advancing excellence in legal education and contributing to the democratic and constitutional vision that defines our nation. On behalf of the university, I extend my deepest gratitude to the Honorable Chief Justice, Honorable Justice Sujit Narayan Prasad ji, the learned Advocate General, dignitaries and esteemed guests present here today for their time, guidance and continued support. Thank you. Now, with the permission of our dignitaries, we will proceed to honor individuals and inaugurate key initiatives presenting excellence and public service. We take immense pride in celebrating the remarkable achievement of Miss Sakshi Jamuwar, an illustrious alumna of the 2016-2021 batch of the NUSRL Ranchi. Hailing from Ranchi itself, Ms. Jamuwar has brought exceptional recognition to the state and to the university by securing All India rank 89 in the Civil Services Examination 2023. She has since been inducted into the esteemed Indian Police Service and allotted the Jharkhand cadre. She is currently undergoing her district practical training, contributing meaningfully to public service and governance. It is our privilege to have her among us today. I welcome you on behalf of NUSRL. With great honor, I request our esteemed dignitaries to kindly felicitate Ms. Jamuwar for her outstanding achievement. My lords, we also take pride in the journey of Miss Malti Hemram, currently pursuing her LLM in Constitution and Administrative Law at NUSRL. She represented India at the German India Innovation Summit 2025, where she was invited to the German and European parliaments to participate in high-level dialogues on strengthening India-Europe partnership. Further, she has been selected by the Indian, German and Belgian embassies for future collaborative initiatives. Prior to this, she represented both the Tribal National Youth Parliament and the State Youth Parliament, making her a distinguished young voice in the field of public policy and governance. I welcome Ms. Malti Hemram. I now request our honorable guests to kindly felicitate Ms. Hemram for her extraordinary contribution and global representation. My lords, now I take this opportunity to present before you some projects which we, with all our pride, took up in this academic year. NUSRL has taken a transformative step towards improving access to justice in Jharkhand through a landmark initiative titled Under Trial Prisoners and Continued Legal Education for Jharkhand, supported by the Ajit Premji Foundation. This initiative aims to address systemic concerns relating to prolonged under-trial detention. Under this project, the university is currently providing legal assistance to over 400 under-trial prisoners, while simultaneously empowering 175 young lawyers through a structured 6-month continuing legal education program. The project also collaborates with under-trial review committees and conducts district-level research to identify procedural gaps, ensuring long-term systemic reform. Through integrated legal aid, training and research, NUSRL aspires to contribute meaningfully to the justice delivery ecosystem of the state. Thank you, sir. Another milestone initiative being launched today is Project Nyaya Setu, undertaken by the Center for Labour Law and Research in collaboration with Central Coalfields Limited under CSR support. This project seeks to advance labour rights and strengthen the socio-economic foundation of workers in Ramgarh and Ranchi. Its objectives include enhancing awareness of labour rights and legal protections, improving employability through structured skill-building programs, facilitating access to fair employment and welfare opportunities, and strengthening dispute resolution mechanisms and grievance redressal systems. Through field engagement and community-focused intervention, Nyaya Setu aims to build an empowered, informed, and resilient workforce equipped with legally and professionally. Thank you, my lords. I now request our esteemed dignitaries to kindly inaugurate the university newsletter. Thank you.
Thank you, ma'am, for that insightful and inspiring overview of NUSRL's recent accomplishments. Your vision continues to encourage us to strive for excellence. Shri Rajiv Ranjan ascended to the August office of the 12th Advocate General of Jharkhand on February 7, 2020, and is a renowned member of the Executive Council of NUSRL. He entered the noble profession of law in 1994. Throughout his illustrious career, Shri Rajiv Ranjan has represented the state in a rich tapestry of constitutional, labor, civil and criminal matters, bringing to each case a rare blend of insight, clarity and commitment. His service as government advocate and special counsel for the Home Department of Jharkhand stands as a testament to his unwavering integrity and steadfast dedication to upholding the rule of law. He had also served with distinction as the Additional Advocate General from 2011 to 2012. Now, I humbly request our esteemed guest of honor, Shri Rajiv Ranjan, to kindly address the gathering and share his valuable insights with our students. Sir, we are honored to have you with us today.
Honorable the Chief Justice, Honorable Mr. Justice Tarlok Singh Chauhan, of Jharkhand High Court, the distinguished Chief Justice, Chief Guest for today's function, Honorable Mr. Justice Sujit Nayan Prasad, Judge Jharkhand High Court, esteemed guest of honor, respected Vice Chancellor Professor Dr. Ashok R. Patil, revered Registrar, Vice Chancellor, Registrar Mr. J. Patnaik, Madam Amandeep Kaur, present today of the dais, Mr. Neeraj Srivastava, Law Secretary, revered members of the Judiciary, Academia, learned colleagues, and my young friends from NUSRL. It is both an honor and a privilege to address this national seminar on the momentous occasion of the 75th year of the Constitution of India. As I stand amid such a distinguished gathering, I am reminded that the Constitution is not merely a legal document, it is a moral heartbeat of our nation, a living testament to India's civilizational wisdom and democratic commitment. As we celebrate the 75th year of our Constitution, which came into effect on 26th January 1950. India stood at a crossroads of despair and hope. We were a nation scarred by the wounds of partition, weighed down by poverty, facing the challenges of unifying extraordinary diversity. And yet, our founders displayed an audacity of faith that continues to inspire us even today. They placed supreme power not in the hands of a monarch or a dictator, nor even in a select intellectual elite, but firmly in the hands of we, the people of India. That singular act of trust laid the foundation of a republic. Unlike any other, a republic held together not by force, but by faith, debate, constitutional morality, and democratic resilience. In the past 70 years, as we all know, the Constitution of India has not only evolved, but it has evolved as a living organism. And not the least, the Supreme Court of India and our constitutional courts, high courts throughout the country have played a defining role in giving meaning and vitality to the Constitution. Through its judgments, the court transformed the Constitution from a statutory text into a moral force. It is impossible to recount this journey without recalling the watershed moments in the constitutional history of our country. More or less, the Constitution can be categorized into different phases of the last 75 years of our existence as a constitutional federal democracy. 1950 to 1960 was the foundation decade, where universal adult franchise was established 21 years plus, which has now been brought down to 18 years. And the reorganization of the states which took place in 1956, which was a very momentous occasion for the country. Throughout the country, the different states were reorganized on linguistic lines. Then came the consolidation stage, 1960 to 1980, where we saw a number of precedents rules being imposed and more frequently being used. Then we saw the amendments of 24th, 25th and the 42nd Amendment, which extended the Parliament's power. And lastly, the emergency of 1975 to 1977, which tested our constitutional limits. Then came the course correction phase, 1980 to 2000. Then came the 44th Amendment, emergency era excesses were recalled, economic liberalization of 1990s, and the rise of the coalition politics. 2000 to 2020 saw momentous legislations like right to education, right to information, Food Security Act, and the landmark Supreme Court cases on privacy, LGBTQ plus rights, etc. Then 20 to 25, the new debates continue, where we see a number of constitutional courts, constitutional benches of the Supreme Court being consulted to decide a number of landmark judgments. And recent judgment which has come on the presidential reference about the president's power and the governor's power under Article 143 and Article 200 of the Constitution of India. When we recall the watershed movement, all these I am only saying for the reason that it is the Supreme Court as a constitutional sentinel of our country, and the constitutional courts, high courts throughout the country, they have preserved the morality of the Constitution, and they have acted as the backbone of the Constitution and have ensured that the Constitution survives not only as a text, as a document, but as a living organism and dynamic. The Kesavananda Bharati judgment, as we all know, a 13-judge bench declared that even Parliament cannot alter the basic structure of our Constitution. The basic structure doctrine was for the first time promulgated here, and it has stood as a bedrock of our Constitution now, where a number of judgments have come thereafter, which has reaffirmed the basic structure doctrine. Then we can also recollect about the S.R. Bommai judgment, which prevented the misuse of Article 356 of the Constitution and unequivocally established secularism as a part of the basic structure. The court affirmed that federalism is not a concession, but a fundamental design of our democratic architecture. This principle continues to resonate even today, especially in the area of heightened center-state interactions, fiscal federal debates, and evolving cooperative governance. The transformative mandate of the Constitution is perhaps most evident in its pursuit of social justice. The landmark decision in Indira Sahni judgment, which affirmed the 50% reservation under Article 16(3) of the Constitution of India, Article 16(4) of the Constitution of India, and many other judgments which has come thereafter, affirming Indira Sahni judgment, like Jarnail Singh case and other judgments, which has reaffirmed our faith in our Constitution and as a affirmative state action for removing inequality. Then we should remind ourselves with the educational reforms judgment in the TMA Pai Foundation case. And there was subsequent judgments also which has come to clarify the ratio of the TMA Pai judgment. One of the major landmarks was the Minervaville case and the Maneka Gandhi judgment on Article 21, where the right to privacy and Article 21 was enlarged to an extent that now Article 21 encompasses all kinds of freedom, human rights including, as well as natural justice rights and every other right which can come under a broad umbrella of Article 21. Justice K.S. Puttaswamy judgment, the court recognized the privacy as intrinsic to dignity and liberty, shaping debates on data protection, surveillance, bodily autonomy and technological governance. It reminded us that the constitutional rights must evolve with human realities. Post Puttaswamy, a series of progressive judgments reaffirmed the Constitution's deep commitment to human dignity. In Navtej Singh Johar, the court decriminalized the consensual same-sex relationships, affirming that constitutional morality must triumph over social morality. In Joseph Stein, the court struck down the colonial adultery provision for treating women as a property. In Saira Bano, the instant triple talaq was declared unconstitutional. In Common Cause, the right to die with dignity was recognized through advance directives. These decisions collectively elevated the sanctity of dignity as a central pillar of constitutional governance. The decision in Union of India versus ADR mandated the disclosure of criminal history of candidates, empowering voters with the right to make informed choices. The Lily Thomas judgments ensured that the convicted legislators could not remain in office. Vineet Narayan revolutionized the independence of investigative agencies, and the recent landmark ruling on electoral bonds reaffirmed that transparency is the heartbeat of democracy. No democracy can survive in shadows. Sunlight, as the court reminded us, is the best disinfectant. The Constitution has also blossomed into an environmental charter. From the early decisions in Ratlam Municipality, MC Mehta and Vellore Citizens Welfare Forum, the court has expanded the Article 21 to include the right to clean air, pure water, environmental sustainability and ecological balance. We still remember Honorable Justice Kuldeep Singh as a sentinel of environmental reforms. Institutional integrity remains the cornerstone of our constitutional survival. The judge's case, which shaped the collegium structure, underscored that judicial appointments must be insulated from excessive dominance of the executive. More recently, the Supreme Court's pronouncements on the appointment process of election commissioners reiterated that independent institutions are essential for fair elections and sustained democracy. Our Constitution survives because our institutions, though challenged, have not yielded to their soul. The challenges confronting the Constitution today are unprecedented. Technology is transforming every facet of governance and citizenship. Issues of data protection, cyber security, artificial intelligence, algorithmic bias, misinformation, and deepfake manipulation pose serious threats to privacy, consent, autonomy, and our democratic institutions itself. The foundation laid in Puttaswamy guides us, but the truth is clear. The constitutional jurisprudence of the digital age is only beginning. Our courts and lawmakers will need to navigate this terrain with wisdom, balance, and foresight. As we stand today at the threshold of the Constitution's next 75 years, many of us here would not be present in the next 75 years maybe. But looking ahead to its centenary in 2050, we must reimagine our constitutional priorities. A renewed emphasis on constitutional education is vital. Citizens must understand the Constitution not merely as a political charter, but as a guide for ethical civic behavior. Digital rights must evolve to protect autonomy in an age of pervasive technology. Institutions must be strengthened, insulated from pressure and guided by integrity. Social justice must adapt to changing realities while preserving equality. Ecological stewardship must become central to constitutional governance, and federalism must deepen through genuine cooperation. The Constitution's future depends on how faithfully we pursue these commitments. To the students and young scholars in this hall, the future of the Constitution, I would say, rests in your hand. You will be the interpreters, defenders, reformers, and custodians of this republic. The Constitution is not a closed book. It is not an invitation to think, but it is an invitation to think, question, reform, and renew. As Justice Rohington Naiman so memorably reminded us, the Constitution is not made for the generation that writes it. It is made for the generation that reads it. I ask each one of you, read it deeply, live it sincerely, and defend it courageously. 75 years after birth, the Indian Constitution stands as one of the most extraordinary democratic achievements in human history. Adaptable yet principled, resilient yet compassionate, rooted in Indian realities yet universal in its wisdom. It has survived wars, it has survived emergencies, political upheavals, social conflicts, and economic transitions. We can still visualize the Gen Z movement in Nepal, what is happening in Pakistan, what happening in our neighboring states of Sri Lanka and Bangladesh. We should feel honored to have a constitution and our constitutional courts to preserve it and protect it. It has survived because the people of India believed in its values. That collective belief is the greatest strength, and that belief must continue to guide us. Let us therefore commit ourselves on this historic occasion to ensuring that the Constitution's next 75 years are even more enlightened, inclusive, just, and humane. Let us reaffirm our faith in the document that does not merely govern our nation, but elevates our national conscience. The Constitution is not an instrument of governance alone. It is an instrument of transformation, a mirror of our ideals, a map of our collective future. Allow me to conclude with these words. A Constitution does not merely govern the nation. It inspires the nation to become what it ought to be. Thank you all.
We express our heartfelt gratitude to you, sir, for your enlightening address. Thank you for taking the time to inspire us today. Now, we are privileged to hear from Honorable Mr. Justice Sujit Narayan Prasad, Honorable Judge, High Court of Jharkhand. His Lordship holds a master's degree along with a degree in law. He was elevated as Honorable Additional Judge of High Court of Jharkhand and took oath on 26 September 2014. Subsequently, he served with distinction at Orissa High Court from March 2015. Upon his repatriation, his Lordship resumed at the Jharkhand High Court on 26 November 2018 and has been entrusted with responsibilities of acting Chief Justice on multiple occasions. His Lordship has served on several important committees, including those relating to judicial training, computerization, e-governance, juvenile justice, and more. We are honored to have him with us today. I now invite Honorable Justice Sujit Narayan Prasad, Honorable Judge, High Court of Jharkhand, to address the gathering.
Honorable Mr. Justice Tarlok Singh Chauhan, the Honorable the Chief Justice of Jharkhand High Court, the Chancellor NUSRL, Mr. Rajiv Ranjan, Learned Advocate General Jharkhand, Professor Dr. Ashok R. Patil, Vice Chancellor NUSRL, Madam Dr. Amandeep Kaur, the faculty member also of the NUSRL, Mr. J. Patnaik, the Registrar, Mr. Prashant Kumar Singh, Mr. Radhe Krishna Gupta, the Learned Registrar General Mr. Satya Prakash Sinha, Mr. Neeraj Kumar Srivastava, the Law Secretary, Mrs. Miss Ranjana Sthana, Member Secretary, the members of the Registry of the Jharkhand High Court, all faculty members, the ladies and gentlemen, and particularly to the students, a very good evening to all. At the outset, let me begin my congratulating NUSRL Ranchi for organizing national seminar on 75th years of the Indian Constitution. I am immensely pleased and extremely happy and proud to be here amidst all of you for this occasion. I am thankful to the organizing committee for giving me this opportunity. It is a pleasure and privilege to share the dais with Honorable the Chief Justice of Jharkhand High Court on this occasion. It is an honorable moment for all of us to have your prestigious presence in the today's seminar, Lordship. His Lordship is an inspiration for many as the accomplishment he has made are unforgettable. It is a well-known proverb that actions speaks louder than the words. And for the personality like him, the proverb is quite apt. As we all know, India commemorated a historic milestone on the 26th November 2024, marking the 75th anniversary of the adoption of the Constitution of India. November 26, 1949 is a red letter day in the history of our country. The day on which we adopted our Constitution, it came into force on 26th January 1950. I recall a very pertinent expression from the architect of the Constitution, Dr. Bhimrao Ambedkar Sahab, according to whom, quote, Constitution is not a mere lawyer's document. It is a vehicle of life and its spirit is always the spirit of age, unquote. When the Constituent Assembly adopted the Constitution, it gifted us more than a legal framework. It offered a vision of justice, liberty, equality, and fraternity. A vision woven with the threads of diversity, democracy, and dignity. More than 7 decades later, the Indian Constitution remains not just a document but a living force, shaping India's political, social, and moral landscape. The framers of the Constitution recognized India as a complex socio-political fabric and designed a document that would facilitate unity in diversity. By balancing local needs with national interest, fostering dialogue, and adapting to changing circumstances, the Constitution has played a pivotal role in maintaining India's unity and integrity as a diverse nation. The Constitution of India lays down the framework demarcating fundamental political code, structure, procedure, powers and duties of government institutions, and set out fundamental rights, directive principles, and the duties of citizens. It is the longest written constitution of any country on earth. Friends, the preamble to the Constitution identifies securing social, economical, and political justice for all citizens. Our forefathers have allowed us to carry forward the dreams of creating a nation ruled neither by historical injustices nor by personal whims of dictators, but by a democracy most vibrant and ever aspiring to uphold the core of our Constitution. The term democratic is used in preamble in the broader sense, embracing not only political democracy but also social and economic democracy. The term socialist denotes democratic socialism. It means a political economic system that provides social, economic, and political justice. In the case of Excelsior versus Union of India, the Honorable Supreme Court found that the principle of socialism and social justice cannot ignore the interest of different section of society, majority of the private owners. In the case of DS Nakara versus Union of India, the court held that the basic purpose of socialism is to provide a decent standard of life to the people living in the country and to protect them from the day they are born till the day they die. We all know that the Constitution of India is a right-based constitution because it enshrines a comprehensive set of fundamental rights in Part 3, which are legally enforceable and protect individual liberties from state encroachment. These rights, often called the Magna Carta of India, include the right to equality, right to freedom, and right to freedom of religion, among others, and are safeguarded by the judiciary. In an age where societal tensions, digital spaces, and political debates sometimes test these rights, the Constitution remains our anchor. The equality before law implies that every individual, be he a high dignitary or a wealthy person or a member of any particular caste on the women, stands in the same relationship with the law. The concept of equality before the law brings to light the absence of any discrimination in status. Such a principle makes sure that every citizen is equal before the law, which goes hand in hand as an important component of the rule of law. In the case of E.P. Royappa versus State of Tamil Nadu, that 1974, where Justice Bhagwati articulated a new dimension in equality concept and has observed that equality is antithetic to arbitrariness. In fact, equality and arbitrariness are sworn enemies. Where an act is arbitrary, it is an implicit in that it is unequal both according to political logic and constitutional law, and is therefore violative of Article 14. Thereafter, the judgment has come in the case of Maneka Gandhi, that Constitution Bench judgment 1978, followed by the judgment of Ajay Hasia, reiterating the same view. The concept of rule of law would lose its vitality if instrumentalities of the state are not charged with the duty of discharging their function in a fair and just manner. In a system governed by the rule of law, there is nothing like absolute or unbridled power exercisable at the whims and fancies of the repositors of the power, but power exercised only along well recognized and sound juristic principles with a view to promoting fairness, inducing transparency, and aiding equity. Further, that Article 16 takes care of to maintain the right to equality by providing opportunity in the matter of employment, but also taking care of by granting reservation to the downtrodden people so that they may come in the mainstream of the society, but keeping into consideration that there may not be imbalance in the public employment. That has been taken care of mostly in the case of Indira Sahni by giving a ceiling of 50%, that the reservation is not to be exceeded 50%, followed by R.K. Sabharwal that in the matter of reservation the roster is to be followed. So the balance has been tried to be maintained, and it is being maintained by the judicial pronouncement made by the Honorable Apex Court to maintain the sanctity of the Constitution of India. Article 16(4)(d) has been inserted for the purpose of giving consequential benefits in the seniority. That has been taken care of by Honorable Apex Court in the case of N. Nagaraj. Ultimately, the matter has been set at rest in the case of Jarnail, seeing that what is the parameter to be followed so that the imbalance may not be created. The meaning thereby that the Honorable Apex Court time and again has maintained the sanctity of the Constitution so that there may not be any imbalance, and the constitutional setup as per the framework of the Constitution may not be disturbed. As under the power of judicial review, the care has also been taken recently by inserting 103rd Amendment to give benefit of reservation to the economically weaker section, so that the persons who are living in by virtue of the financial condition are weaker, then the arrangement has been made to grant 10% reservation to such category of the employee. That has also been upheld by this Honorable Apex Court recently. The Article 21, the right to life, right to liberty, has also been taken care of by interpreting that what is the spirit of Article 21. And even in the matter of bails, the Article 21 has been taken care of by series of pronouncement of the Honorable Apex Court. And that has been made applicable even in the case of UAPA or the PMLA, whatever may be the nature. That is the spirit of the Constitution, that it cannot be infringed if there is no valid reason. So the right to privacy has also been taken care of recently in the case of case Puttaswamy versus Union of India 2017. Thus, from a sources it can be deducted that Article 21 is the perfect example of the transformative character of the Constitution. The Indian judiciary has attributed wider connotation and meaning to Article 21 extending beyond the Constitution maker's imagination. These meanings derived from the right to life present unique complexities. The subsequently that the Article 21, the right to education, has also been inserted under Part 3 as a fundamental right. The next basic feature is the governance under Indian Constitution and separation of power, that how the good governance is to be given. And it has been interpreted in the Constitution Bench Judgment 1978, some saying that even the Prime Minister or the Chief Minister or the Governor or the President in individual capacity is not competent to take any decision, because you are living in the setup of collective system. So that time and again it is being interpreted by Honorable Affairs Court how to maintain the sanctity of the Constitution of India. The basic feature is that separation of power, that we are having the three pillars. Prior to 73rd and 74th Amendment, that there was the three pillars, the executive, legislature and the judiciary. Judiciary has been given the power under the power of judicial review to make balance in between the system, so that the constitutional mandate be maintained, but without encroaching upon the power which has been conferred and which is to be exercised as per the constitutional mandate by the scrutiny of the legislature. We are having with the three-tier system, but by virtue of insertion of 73rd and 74th Amendment, the local bodies and the panchayati system has been strengthened, so that the people in the local area, the remotest area, may have the feel of the governance, so that the remotest area, the people living in remotest area may have their participation in the governance and they may be benefited. We are having with the basic structure of the Constitution that has been held to be not disturbed. Even the preamble has been subsequently been interpreted by Honorable Affairs Court that the preamble is also coming under the fold of the basic structure that has been dealt with by the 13 judges bench of the Honorable Affairs Court in the case of Anand Bharti case. So the 42nd Amendment, that preamble initially was only 3 elements, but it was by virtue of 42nd Amendment, the socialist and secular were added between sovereign and democracy. Unity of the nation was changed to unity and integrity of the nation. However, the Minerva Mills versus Union of India 1980 Supreme Court, the Supreme Court invalidated provisions of 42nd Amendment Act and ruled that the Parliament cannot take away the power of judicial review as it is a part of the basic structure. Thereafter that we have having with the 85th Amendment that has been taken care of by the Honorable Affairs Court in the Kehoto Holan case, that anti-defection. So the SR Bombay judgment as has been said by Learned Advocate General. So Supreme Court, in order to keep the mandate of the Constitution intact, is interpreting by taking care of the various issues time and again. Now we are celebrating 75th Amendment. We are here, you are here, you have to go long. So maintaining the constitutional spirit is depend upon the people who is to handle the document. If the people will not go, certainly the document cannot speak and the purpose will not be achieved. So with this that we are having the 75th anniversary of the Constitution, India is to go long. So it is now your accountability as a member of the legal fraternity, the law student, to how to maintain the sanctity of Constitution, so that our country may grow and have a mark across the world. With this word I conclude. Jai Hind.
Thank you so much, Your Lordship, for your gracious and insightful address. We are deeply honored by your presence and grateful for the valuable thoughts you have shared with us today. Your words will serve as a great source of inspiration for our students and faculty alike. And we believe and we hope that we will definitely maintain the sanctity of the Constitution, as you said. Thank you once again, sir. Now, it is with great honor to introduce our chief guest, Honorable Mr. Justice Tarlok Singh Chauhan, the Chief Justice of Jharkhand High Court, cum Chancellor of NUSRL Ranchi. Your Lordship is a true visionary and an inspiring luminary of the legal fraternity, whose illustrious journey began in 1989 with his enrollment as an advocate with the Bar Council of Himachal Pradesh. Commencing his practice before the High Court of Himachal Pradesh, he soon distinguished himself through his unwavering commitment to justice and public service. Over the years, he has been integrally associated with legal aid programs, served as a valued member of various lok adalats, and rendered his expertise as standing counsel cum legal advisor to the Himachal Pradesh State Electricity Board Limited and Himachal Pradesh State Civil Supplies Corporation. Elevated as an additional judge of the High Court of Himachal Pradesh in 2014, Your Lordship has continued to exemplify judicial excellence, compassion, and foresight. His Lordship's enduring commitment to the welfare of children is particularly noteworthy. As chairperson of the Juvenile Justice Committee of the High Court for nearly a decade, he worked tirelessly to advance the rights, protection, and holistic development of children. His participation in the International Learning Exchange Program in Romania, focusing on the reform of care and protection systems for children, stands as a testament to his global vision and dedication to progressive reform. He has also graced numerous national and international conferences with his profound insights and wisdom. Your Lordship has further contributed significantly to legal academia as a member of the Governing Council and Executive Council of HPNLU Shimla. His Lordship has also worked for the digitalization of courts. Now, with utmost respect, I humbly request the Honorable Mr. Justice Tarlok Singh Chauhan, Chief Justice of the Jharkhand High Court, to kindly address the gathering. Sir, it is our privilege to hear from you today.
Thank you for the introduction. I've been observing here that probably the audience has lost its patience, is yawning away to glory, but you'll have to tolerate me for some more time. The reason being the importance of the topic. Why the Constitution? Why not legal theory or something else? Please remember, all of you who have chosen this path of joining the law course, for you this would probably be everything in your life now. What do you say, henceforth? Why? Because please remember, Constitution is the fountainhead of all legislations. So unless until the provisions of the Constitution are not infused in your bloodstream, probably you will never understand any law, at least the codified law. So therefore it is this Constitution which is so important and vital for us. That apart, as the learned Advocate General put it very peculiarly, that's probably because of this Constitution that we've been able to survive the wars, the emergency, and recently even the pandemic. We didn't have lawlessness. And probably I attribute that only to the working of the Constitution. If it was not but for the Constitution, probably we might have landed up in a mess given the fact that we are 1.4 billion people. Yet we can unite. I think one of the chapters we have unity in diversity or something. Probably that's one of the first fundamental chapters which are taught to all of us. So that's the importance of this Constitution. How with such diverse background we are still united. Not on purpose alone, so many things. The dignitaries on the dais, off the dais. I won't take a roll call because we are running out of time and I can see the audience getting impatient again. Today we gather not merely to commemorate the adoption of a constitutional text, but to reaffirm a constitutional faith. The Constitution of India, adopted on 26th of November 1949, was far more than a legal charter. It was a civilizational proclamation, an enduring affirmation. The destiny of our republic shall be shaped through reason, guided by deliberations, and governed by solemn discipline of law. The preamble of a constitution enshrines a collective pledge to justice, social, economic, and political, to liberty of thought, expression, belief, faith, and worship, to equality of status and opportunity, to fraternity, which secures the dignity of every individual and safeguards the unity and integrity of our nation. These are not merely ornamental ideas, they are solemn constitutional commitments, living promises that guide our institutions, inspire our governance, and binds us as a republic governed by the rule of law. At the very moment of its birth, our Constitution made a deliberate and transformative choice that India shall be governed not by force, but by law, not by dominion, but by constitutional discipline. This foundational commitment reshaped the charter of the Republic. Article 21, which is much talked of, in its original phrasing, appeared to offer a procedural safeguard that no person shall be deprived of his life or personal liberty except according to procedure established by law. Yet, as a constitutional jurisprudence matured, the arc of landmark decisions from A.K. Gopalan to the watershed judgment in Maneka Gandhi, this guarantee was elevated from a narrow procedural protection to a rich substantive promise. Life and liberty came to be understood as dignified, meaningful, expansive, and real, forming the very moral core of a constitutional order. Justice Oliver Wendell Holmes famously observed, and I quote, "The life of law has not been logic, it has been experience." Unquote. Nowhere is this more profoundly true than in the evolution of India's constitutionalism. Our constitution has not grown through the rigidity of text alone, but through lived interpretation, through the moral and social experience of a plural, diverse India, and through an unceasing constitutional dialogue between the courts, the legislature, the executive, and the people. It is in this continuous conversation that a constitution is alive, responsive, and enduring. Over 7.5 decades, a constitution has not merely withstood transition, it has actively shaped them. In Keshavanand Bharati, we discovered the basic structure doctrine, an innovation without parallel in the annals of comparative constitutional law in the world. In Minerva Mills, we reaffirmed that limited government is not a political slogan, but the structural essence of our republic. In S.R. Bommai, the federal character of the constitution was shielded against partisan disruption. In Indira Sahni, we achieved a careful equilibrium between equality, representation, and social justice. And in Puttuswamy, the right to privacy was placed at the very heart of dignity in the digital age. Each of these milestones has deepened our constitutional commitment and strengthened the architecture of our democracy. This evolution reminds us that the Constitution is not a static text, it is a dynamic conscience. And the conscience of a Constitution must remain firmly anchored in Article 14, 19, and 21, not as discrete provisions, but as an inseparable tirade that forms the moral architecture of the Republic. Together they constitute the heartbeat of a constitutional order, safeguarding equality, liberty, and the dignity of every individual. Constitutional morality is not an ornamental philosophy. It is an enforceable constitutional discipline. It demands that our institutions remain anchored not in the outcomes of conveniences, but in the outcomes of principles. Judicial review must never degenerate into judicial supremacy, yet with equal force. Judicial restraint must never slide into judicial abdication. Article 32, which Dr. Ambedkar described at the very heart and soul of our Constitution, guarantees every individual the right to approach the Supreme Court for the enforcement of fundamental rights. Article 226 vests the High Court with a broad and potent jurisdiction, making them the first sentinel of the Kiwi for liberty and constitutional justice. They are not mere procedural avenues, they are structural guarantees of accountability, ensuring that the Constitution remains a living instrument, not a ceremonial relic. Constitutional morality therefore demands of the judiciary intellectual honesty, institutional humility, and the courage of principled reasoning, and it requires from both bar and bench a shared fidelity that constitutional interpretation must remain unswayed by sentiment, untouched by ideology, unconditioned by political expectations, and guided solely by constitutional purpose. In Jharkhand, constitutional interpretation cannot proceed from the serenity of an ivory tower. Here, constitutional values are not abstractions, they are lived realities. When the Constitution promises equality under Article 14, personal liberty under Article 21, or freedom of expression under Article 19(1)(a), these guarantees take on concrete meaning, shaping questions of land and livelihood, displacement and resettlement, cultural continuity, indigenous identity, and the just distribution of resources. The jurisprudence of the fifth schedule, deepened by transformative decisions such as the Samantha, has taught us that constitutional rights in tribal regions extend far beyond the protection of land titles. They safeguard the identity, autonomy, and constitutional personality of entire communities whose relationship with their land is ancestral, spiritual, and civilizational. Jharkhand repeatedly affirms the profound constitutional truth. Dignity here is not mere a philosophical ideal. It is a territorial, economic, cultural, and ancestral, and inherently constitutional. This is a state where constitutional democracy meets the lived reality of people in its most elemental form. Therefore, constitutional adjudication in Jharkhand is not merely an exercise in legal reasoning. It is an exercise in constitutional empathy, requiring a sensitivity to history, a respect for identity, and a fidelity to the transformative spirit of the Constitution. In our time, public discourse has become instantaneous. Narratives crystallize before facts are fully known. Opinions harden even before constitutional principles are examined. In such an atmosphere, the judiciary must remain the final forum where constitutional patience is still honored and practiced. Courts cannot be allowed to transform into arenas from ideological triumph. They must remain sanctuaries of constitutional reason. The legitimacy of the judiciary does not flow from public applause, but from an unwavering fidelity to the Constitution. In Hafte Jaur, the Supreme Court reaffirmed that constitutional morality is not social morality, must guide judicial interpretation. In Joseph Shine, patriarchal norms were held incapable of constitutionalization under the guise of custom. In Saira Bano, dignity was placed at the very heart of personal liberty. Each of these judgments teaches a vital lesson. The Constitution must remain the antidote to majoritarian emotions. Judicial responsibility in the 21st century therefore extends far beyond declaring what the law says. It demands a vigilant guardianship of what the Constitution means. Today, technology has transformed the very nature of power. Private digital platforms now influence public opinion more profoundly than many state institutions. Data has emerged as an instrument of behavioral control. Algorithms can shape perception. Artificial intelligence can mold the very process of consent formation. These developments create constitutional vulnerabilities that the framers of 1949 could not have foreseen, yet ones that the judiciary must confront with clarity and foresight. In Puttaswamy, the Supreme Court affirmed that privacy is intrinsic to dignity. But in an age of biometrics, predictive analytics, persuasive surveillance, and targeted digital advertising, the soul of privacy demands protection not from the state, but from the concentrated and unregulated private power. Constitutional rights must remain enforceable not merely in the physical world, but equally in the rapidly expanding digital domain. The Constitution cannot be diminished simply because technology has become more powerful. If anything, the rise of technological power strengthens our responsibility to ensure that constitutional guarantees remain robust, relevant, and real. The framers did not craft a constitution of institutional hostility. They crafted a constitution of institutional balance. The doctrine of separation of powers is not a doctrine of supremacy. It is a doctrine of limitation. And in a constitutional democracy, limitations is the greatest safeguard of liberty. The executive is entrusted with the implementation of policy. The legislature embodies the democratic will of the people. The judiciary guards the constitutional boundaries within which all power must operate. Each institution is indispensable. None is absolute. The Constitution envisions institutions that converse, not confront. When Parliament, the executive, and judiciary engage not as rivals in competition, but as partners in constitutional responsibility, it is only then that the supremacy of the Constitution is truly realized. In S.R. Bommai, federalism was reaffirmed as a part of basic structure. In Minerva Mills, the principles of limited government were reaffirmed. In Keshwanath Bharati, the court declared that the Constitution is not open to majoritarian redesign. Thus, constitutional democracy is preserved not through dominance, but through balance, through the harmonious exercise of power within the constitutional limits. Friends, as we look ahead to the next 25 years, India will enter a phase of constitutional complexities never seen before. The next quarter century will test not only interpretation, but constitutional imagination. We will need deeper development of equality, jurisprudence in Article 14, beyond formal sameness into substantive empowerment. We will need deeper expansion of liberty under Article 21, where liberty is not merely an absence of restraint, but presence of constitutional capability. We will need a more stable, principle-based free speech doctrine under Article 19(1)(a), as speech now shifts to virtual architecture, where platform power can distort democratic reasoning itself. Constitutional dialogue must evolve to protect intergenerational justice, environment equity, platform neutrality, data ethics, deepfake manipulations of reality, AI distortions of public choice, and algorithm bias. Puttaswamy opened the gates. The next evolution must ensure privacy, autonomy, and human dignity survive the most powerful forces of modern influences, commercial, ideological, and geopolitical. The judiciary must continue to earn the trust of the people each day, not through assertion of authority, but through the steadfast demonstration of principle. Judicial credibility is never built in a moment. It is strengthened each time a judge chooses constitutional fidelity over momentary popularity. When a citizen enters a courtroom, the courtroom must remain the one space in the republic where identity dissolves and only constitutional reason prevails. This is the moral force of Article 32 and 226. They make constitutional justice accessible without privilege, without status, and without power. Judicial independence, therefore, is not designed to create judicial power. Judicial independence exists to ensure judicial neutrality, and it is the judicial neutrality, consistent, visible, and principled, that nurtures public confidence in the institution. The judiciary must remain ever conscious of a timeless truth. Justice must not only be done, it must be seen to be constitutionally done. Every constitutional day we must ask ourselves a solemn question: have we remained faithful to the founding constitutional promise, not merely in letter, but in spirit? In Maneka Gandhi, the Supreme Court transformed procedure established by law into a guarantee that such procedure must be fair, just, and reasonable. In Nafte Jor, the court reaffirmed that minority identity cannot be subordinated to the weight of majority sentiments. In Indra Swami, affirmative action was recognized not as charity, but as an instrument of constitutional justice. In Vishaka, gender justice and equality and dignity were given enforceable constitutional content. Each of these decisions illuminates a simple truth, that the Constitution is not a museum artifact. It is a living, breathing source of hope, a continuing bridge between our constitutional aspirations and our constitutional realities. Our responsibilities, therefore, are not to commemorate the Constitution. Our responsibility is to realize it. As we stand in Jharkhand, a state that represents both civilizational ancestry and constitutional modernity, the message of the Constitution becomes exceptionally profound. Because here in this land, constitutional morality is tested not in debates, but in lived human experience. Let us therefore reaffirm today that power is not the measure of a nation's greatness. Restraint is. Strength is not the ability to prevail. Strength is the ability to remain just. That is the moral force that a constitution placed above all institutional desire for dominance. Let this constitutional day remind us that Constitution of India is not merely a text we interpret. It is a promise we must keep. Let this day remind us that liberty, equality, and fraternity are not slogans written in the preamble. They are duties we must operationalize through every constitutional interpretation, every judicial decision, every institutional choice. Let this day remind us that the constitutional democracy survives not because it is written, but because it is lived. Thank you. Jai Hind.
Thank you, Your Lordship, for your profound and inspiring address. We are truly honored and deeply grateful for your presence today. To formally conclude today's inaugural ceremony, I now invite Dr. Avinash Kumar, Assistant Professor, NUSRL, to deliver the vote of thanks.
Thank you, ma'am. Good evening, all of you. I, Dr. Avinash Kumar, Assistant Professor of Law, NUSRL Ranchi, proud privilege to extend a heartfelt vote of thanks on behalf of NUSRL at the conclusion of the inaugural session of National Seminar on 75th years of Indian Constitution, Contemporary Reflections and Future Directions. First and foremost, we express our deepest gratitude to Honorable Chief Justice, Mr. Justice Tarlok Singh Chauhan, High Court of Jharkhand, cum Chancellor, NUSRL Ranchi, for gracing this occasion with your esteemed presence. Your insightful reflections on constitutional principles and the evolving role of judiciary have enriched today's discourse in a profound way. We are truly honored to have had the opportunity to learn from your wisdom, sir. Our sincere thanks go to and Prasad, Judge, High Court of Jharkhand, for your thought-provoking address. Your perspectives on constitutional interpretation, judicial responsibility, and contemporary legal challenges have added immense value to this seminar. We are grateful for the time and guidance you have extended to us, sir. Our heartfelt appreciation goes to Sri Rajiv Ranjan, Advocate General, State of Jharkhand, for taking time out of your demanding schedule to be with us. Your address, marked by clarity and practical wisdom, has greatly contributed to the intellectual rigor of this seminar. We are thankful to our respected Vice Chancellor, Sir, Professor Dr. Ashok R. Patil, whose constant encouragement and visionary leadership made this seminar possible. Your commitment to academic excellence and to fostering meaningful legal scholarships continues to inspire the entire university community, sir. A special word of thanks to our Assistant Registrar in charge, Dr. Jishu Ketan Patnaik, sir, for your unwavering support and administrative coordination, which have been instrumental in the successful organization of this event. I would like to thank Ms. Sakshi, IPS, and Dr. Amandeep Kaur, ma'am, who recently joined NUSRL, Professor Ramashankar Dubey, sir, Vice Chancellor, Birsa Agricultural University, Professor S.P. Agarwal, sir, Vice Chancellor, Sainath University, Srimati Nidhi Jaiswal, ma'am, Assistant Registrar, BIT Misra, all the members from the judiciary, Jhalsa, and academics. A special note of appreciation goes to the organizing committee, especially Samla ma'am, Dean, Academic, NUSRL Ranchi, all the faculty members, administrative staff, and student volunteers whose dedication, hard work, and meticulous planning ensured the smooth and successful conduct of this event. Thank you all once again. Thank you. Jai Hind. A small announcement for tomorrow program. On 26 November 2025 is Law Day and Constitutional Day. So we start from 11 o'clock. 11 to 11:10 we will reciting of the preamble of the Constitution of India on the occasion of 75 glorious years of